Welcome back to the East Asian Leadership in International Video Lecture Series. This time, we are going to talk about national practice of Japan for the interpretation and application of international law. First, we have to touch upon the Japanese imperialism. Japanese international law after the Meiji era, which was characterized by the Japan-style empiricism and the distinction between the West and Great Asia, was developed through the expansion of the Japanese imperialism in connection with the West. Temporarily, it was when Japan's modern state formation coincided with the era of imperialism. In the context of the phase of the being in Asia, an Asian, not yet of Asia, the current Japan trend is to detach itself from Asia. In the process of the Japan accepting its position as an Asian country, a methodological framework is required for its relationship with Europe and America. Various discourses suggest that through civilization and race, Japan confirmed its integration in Asia based on its differences with Europe and America, and through culture and people. Japan established an internal hierarchy within Asia, with the regional order being reformed in the manner of the Japanese imperialism. Such a discourse can be understood as a distinct aspect of the Japanese imperialism and its colonization driving use of international law and treaties. In other words, Japan's utilization of international law fundamentally aligned with the Western imperialist states' the process and methodology and the purpose. Let me give you some examples as a case studies. The first, we have to touch upon the Japan's release of the nuclear contaminated water and its potential risks and concerns. Since last August of the last year, Japan has been discharging contaminated water from the Fukushima nuclear plants. Both domestically and internationally, there has been sharp opposition regarding the safety of contaminated water that will be discharged after treatment. The nuclear accident resulting from the 2011 Great East Japan the earthquake is one that could occur to any state using nuclear power. Nevertheless, since the contaminated water will be discharged into the international waters, it will impact not only Japan's neighboring countries, but it will also impact the interests of the entire international community. Therefore, the safety of the radioactivity wastewater must be verified through multilateral international cooperation. In turn, Japan must prioritize the dispelling international skepticism regarding the safety of the contaminated water through transparent provision of accurate information. Japan's approach to the release of the nuclear contaminated water mirrors the country's approach to handling the forced labor issues. Japan's fundamental stance on the discharge of the contaminated water can be broadly categorized into two key points. The first, Japan asserts that it did not violate international laws, including United Nations Convention of the Sea provisions regarding marine environmental protection. And the second, Japan contends that the contaminated water it wants to dispose of is not harmful to the marine environment or the people, as is comparable to emission practice of neighboring countries such as Korea and China. In summary, Japan is maintained that it is entitled to proceed with the discharge in absence of any international violations. As a victim of the Japan's discharge of the contaminated water, South Korea is once again faced with significant government and societal turmoil affecting its legislation, judiciary, and administration. In light of the lack of the clear scientific evidence regarding safety of treated contaminated water, neighboring countries have expressed their concerns regarding the potential risk posed by the discharge of the wastewater. In response to Japan's unilateral decision to proceed with the discharge without prior consultation with the adjacent countries, various measures are being discussed in terms of international litigation. Such measures include provisional measures and contentious proceedings before the International Tribunal for the Law of the Sea, initiated by the sovereign state, as well as the advisory opinion from the International Court of Justice through the international organizations or the ITLOS, this through the international agreement related to purpose of the convention. For the ITLOS, to decide upon the appropriate provisional measures, urgent risk and serious harm to the right of the parties concerned need to be demonstrated. Although Japan has formally announced its plan to discharge, providing above two requirements in absence of an actual discharge will be challenging. Similarly, in contentious proceedings, Japan's violation of the international law regarding discharge of the radioactivity contaminated water from Fukushima must be contested. Although the plaintiff states must proceed with the legal procedures promised on Japan's breach of international legal obligations, since the implementation standard of international legal obligations are essentially set at minimum level, it will be difficult to argue that Japan's violation of international law regarding discharge of wastewater is a substantial breach of its obligation. The final report from the International Atomic Energy Agency, IAEA, is expected to serve as a compelling evidence to support contested scientific safety. However, Japan's action regarding release has been an ongoing issue given the lack of the international cooperation, including prior notification or provision of the information and adherence to procedural obligations regarding conservation of the marine environment, including execution of the environmental impact assessment. This issue also closely related to the ongoing lack of communication among the parties involved. Unilaterally, from an international legal perspective, it is highly likely that Japan will be held in procedural rather than substantive violation of the post-discharge regulations under international law. Legally condemning Japan and its state practice is very challenging. For the interpretation and application of international law, which provide the foundation for establishing relations between sovereign states, Japan evades international legal responsibility by adhering to the minimum standard of legality. Japan's historical use of international law, rooted in the rise and fall of empire based on militaristic expansionism, does not reflect morality and contemporaneity. Japan's application of international can be characterized as legal injustice, where morally problematic actions are deemed legally acceptable. As such, challenging Japan via international require meticulous preparations. Those questions including like that. The first, is Japan fulfilling its responsibility in the second and third largest states after the United States among the so-called liberal democratic countries? And second, whether the Japan's criteria and direction, interpretation, and applying international law when considering domestic and international relations, as well as formation of norms demanded by the times. And third, and have appropriate policy alternatives been implemented? And fourth, can Japan lead in the development of international norms? And fifth, how can Japan counter the argument that fundamental cause of the Japan's current state practice lies deeply rooted in the country's culture, such as automatic obedience, unquestioning authority, adherence to domestic, dogmatic, and plans, and collectivism and narrow-mindedness. Therefore, it is important to approach the issue with a long-term policy perspective rather than narrow assessments solely focused on the current discharge decision. It is worth emphasizing once again that the nuclear accident Japan experienced during the 2011 the Hoku earthquake and tsunami in Japan is a disaster can occur in any country that uses nuclear power. History have proven this, and yet there is a clear lack of international norms specifically addressing the disposal of the nuclear waste into the ocean. Hence, the Japan's action regarding discharge of contaminated water from the Fukushima nuclear power plant is a significant precedent and provide a valuable opportunity for the international community to dictate a direction it's aimed to pursue. Failing to seize such an opportunity would be a regrettable occurrence for the international community. Thank you very much for your very kind attention.